Hello everyone, welcome back to the video updates. It's Sade. Today's video is going to discuss, generally speaking, how to go about disputing something in a way that allows you to be able to still assert your claims in the future without losing the opportunity to do so. And when I'm talking about disputes, I'm talking in the context of real estate situations or consumer debt. And of course, real estate debt is also a type of consumer debt. It's just the type that's secured or collateralized. So, so what we tend to get is people calling in and they're very frustrated because they've been trying to dispute usually the payment record on their mortgage loan, or maybe they're disputing the payment record on a business loan or other consumer debt like a credit card. And when people get sued, that is an escalation of a collection process, obviously. So typically there's a period where the other party tries to collect on the debt, and they eventually file a lawsuit, which is either going to be a collection lawsuit in the sense that we're familiar with, which is suing for consumer debt that's unsecured, or it could be a foreclosure lawsuit, which is pretty much wrapped into a collection lawsuit, but also a foreclosure to be able to get control of the collateral. So most of the time people come to us when it's already after the fact. And what I mean by that is the lawsuit already happened, there's already a court judgment involved, and then they're at the point where either the mortgage company or lender is trying to sell that real estate, or they're at the point where the lender is trying to enforce a judgment on a credit card debt or other kind of consumer debt like a medical debt. So when they come to us, they're asking us to undo the payment history to dispute it from the beginning. And the misconception is that you can actually dispute something after there's already a judgment in place. So you can't really dispute something old unless there's not a judgment in place yet. If there's a judgment in place, you do have a period of time to appeal that judgment, meaning that you question the judgment of that particular court or the judge that was in charge of that case, and you appeal it to the next level of court. And typically you have a certain period of time in which you can do that, and it varies by case, it varies by the level of court where you are already. Regardless, it's going to expire maybe after a year and a half. Okay, so this is just a blanket statement just for purposes of letting you realize that you have a short window of time in which to be able to dispute things. It's typically 30 days on the appeal period, and then at the very most, if you have exceptional circumstances, sometimes you have 175 days in which you could try to reopen a case that was already decided. And the reason why the courts don't want people coming back 6 years later to challenge a judgment is that everybody needs some sense of closure. They need some sense of finality, right? To be able to say this thing is settled. So your time to dispute anything that you want to dispute is within that lawsuit while it's still active. And that's something that I wanted to stress in this video. That's one thing that I wanted to stress in this video to make sure that people can hear that. I'm going to repeat that just for emphasis, that the best time to dispute anything that's within the courts is while the case is still active. You do have to dispute it within the period when the case is still active before there's a final order or final judgment. And if you're not successfully able to dispute it, you do want to appeal that judgment if you don't agree with it, and continue to appeal it until all of your appeals are exhausted. And that's the proper way to legally preserve your objections. And of course, you're not going to be able to assert that objection if a judge or a competent court has already decided that the other side is right and you're wrong. So in short, if the court order says you owe $50,000, but you believe that you only owe $20,000, whenever you dispute it again in the future, 6 years down the line, the new court that you're trying to go in front of, they are going to look at the old judgment and consider it as a final word on that issue. So they'll believe that you owed 50,000, not 20,000. And that's just the way it is, because things have to have a time period in which everything has to be done and finalized. And so my suggestion to people is always, once you get served with court documents, or if you hear that you've been sued and somebody's trying to serve you, the best thing is not to avoid getting served. You do want to get served so you can see what the case is about and you can have the chance to defend yourself. So you do want to get served, right? You do want to accept the documents, or at least find a lawyer to help you look things up so that you can see what you're being sued for, how much they're claiming you owe them, and then you can properly defend yourself within the correct window of time that you have, so that you don't lose your ability to object to that information. So you do want to show up, you do want to defend yourself, you want to get a lawyer to help you if there's a big amount in question. You don't want to be on the hook for something that you don't owe. It's best to get money together, pay a lawyer that knows what they're doing, and defend you on time before there's a judgment in place. So again, that thing in Latin, it's called res judicata, and it just means that the thing has been decided, the thing is final, and you don't want to come back years later to try to reverse something that the court did. It's in a very difficult position to be in. You don't have a lot of leverage, and it's very, very difficult, if not impossible, to undo those things. In criminal court, when there's life, limb, or liberty at risk, that's completely different, because you're dealing with more drastic things, and so some things can be undone. But in civil court, we're talking about money, monetary judgments, and so you don't have a lot of leeway to come back later on and say that you don't owe something when you could have defended yourself at the beginning when the other side said you owed it. So that's the way they see it in court. The thing is final, it's done, and so you don't get to come back later to dispute it from the beginning. What you could do, if there's a judgment, let's say in 2010, and we're now in 2020, and you want to dispute that judgment, well, you're not able to dispute the judgment itself. What you could do is use the amount that's inside that judgment from 2010 to do your calculations going forward. So you could still dispute things that might have happened after the day of the judgment, but not before the day of that judgment, unless you did your appeals within the time frame that was required and you won that appeal, right? You still have to win the appeal. And that's my video today for you. I think it seems a little bit unfair that you cannot come back and undo things, but there's a reason why they do that, like I said, and that's just the way it is. It's just to be able to have some closure to cases so that we don't leave them dangling for years and years and years. So if the other parties have followed the procedure they were supposed to follow to notify you of the lawsuit, then yes, you were supposed to show up within that time frame that the law allows. Now, sometimes you have very bad creditors, very bad collection companies, and sometimes, you know, the agents that are working for them that pretend like they've actually followed the procedure, but they really never did. Unfortunately, that happens, and it's very difficult to prove that up, especially when years and years have already passed. However, you can always negotiate something like that down if they already have a huge judgment against you and you don't have the recourse anymore to challenge that. Then you could negotiate a settlement that you're able to afford, or a settlement that makes it a lot better. So what about the people that are within the appeal period? If you are within the appeal period, or within, here in Texas, that 175-day period, which is the extreme window of time that allows you to come back and try to get what we call a bill of review to reopen the case, you might be able to find a lawyer that will be willing to do that. And so you'll find a lawyer that works in that field, which is collection defense usually. And that lawyer can help you. Or if it's a foreclosure type case, then you look for a lawyer that does foreclosure defense, and then also is comfortable doing appeals, and then the lawyer can help you to try to reopen that case. So anytime you think that something was done unjustly and there's a court order in place and you do want to challenge it, you would want to do a consultation with a lawyer right away, and then that lawyer would see whether you were still within your appeal period, all of your possible appeals, to see whether you're within that time frame. And then if it's not within that time frame, that lawyer would also tell you whether there's any extreme measure that you could take to try to undo what's already been done. And so that's how it typically works. The other related question that people ask me is, well, there's a judgment like that, but I filed bankruptcy and I want to let the court know that I never owed that much. Well, it's still the same thing. Even though the bankruptcy court is a different type of court, they will still consider a judgment from a court that has already heard the case and has already decided that you owe that amount. They'll still use that as some sort of conclusive evidence of the amount that you owe. So the other party could very well bring that judgment into the bankruptcy case and submit it as part of their proof of claim to show that you owe $50,000, not $20,000. And then, of course, you're very upset, and I understand that because you never believed that you owed $50,000 in the first place, but that the courts defer to each other sometimes. But the courts defer to each other, so they do have to look at a judgment from a judge that already decided the case or a court that already decided the case, and they can use that as part of the evidence that's supporting the creditor's claim. So yes, it doesn't sound fair. But again, it's because you have to move fast. You have to move within the time allowed by law. So I totally understand that it's frustrating when you cannot go back and dispute things from years and years ago, just because a court already said, this is exactly how much you owed. So that's my quick overview for you. If you have specific questions about your legal case, as always, make sure to talk to a lawyer. Don't try to do it by yourself, especially if it's complex. And sometimes you don't know that it's complex. You just think, oh, I'm just going to ignore this and then it's going to go away, but it's not the case. So the main purpose of this particular video is to tell you that participating is always better than not participating when it comes to lawsuits, okay? Especially if you're a defendant or a co-defendant. You do want to participate, you do want to see what's happening, and you do want to assert your claims within that time period and within that case. And if it comes out that the judgment is against you and not in your favor, you want to see if you would be able to appeal it at the right time, not years later, but in the moment when the thing has happened. So hopefully this is helpful to you, and you let us know what else you want us to cover on the channel, and I'll be happy to do so. Thanks as always for watching, and I'll talk to you next time.